We'll now hear from respondent.
Mr. Chief Justice, and may it please the court. Your Honors, this case is about following the text of a statute where it leads, and when necessary, requiring Congress to speak more clearly on what is prohibited. And there are three reasons why the 924C residual clause should suffer the same fate as Section 16B. First, they contain the same language that gives rise to an ordinary case categorical approach. Second, they share a common history, suggesting similar treatment under the law. And third, the government's proposed conduct-based approach lies beyond the reach of constitutional avoidance. To my first point, Your Honors, that the text of the 924C residual clause requires the ordinary case categorical approach. In Johnson v. United States in 2015, this court identified two features of the Armed Career Criminal Act residual clause that conspired to render it void for vagueness. First,
one feature of the Armed Career Criminal Act is that it applies to previous convictions that happen well before the defendant is sitting on trial for the instant offense. When we talk about applying a categorical approach to that, absolutely makes sense. What I don't understand is how this provision, because it applies to instant offenses, is any different, as Mr. Ehrlich mentioned, from what we ask juries to do in deciding whether something, for example, poses a substantial risk of violence.
In 3 points in response, Your Honor. First, in Johnson v. United States, when this court identified those two features that result in a void for vagueness determination, neither of them turned on the prior conviction context. But
you can't say it didn't turn on that. We weren't trying to distinguish between prior offenses and current offenses. It just so happened that they were prior offenses. But in hindsight, that seems to make a good degree of sense, that when we're talking about prior offenses as contrasted from the instant offense, particularly as we're trying to figure out what a defendant, what a criminal, I guess, or a potential criminal is thinking about when he or she makes a decision to commit the crime, I just don't see how the categorical approach makes sense.
In Your Honor, the categorical approach makes sense largely for four reasons. First, based on the text that Congress chose, already interpreted by this court, most importantly in Leocal versus Ashcroft in 2004. Second, the amendment history to these statutes indicates that Congress intended Section 16 in the Section 924C definition of crime of violence to have the same meaning. And we know that because in 1984, when they were both first enacted, they had to have meant the same thing because they were conjoined by cross-reference at that time.
That means they must have meant the same thing, even though 16B deals with immigration offenses.
So 16B deals with immigration offenses in some contexts, but Section 16 is a standalone, multi-purpose, statutory definition of crime of violence that's cross-referenced by many other provisions in the United States
Exactly, but it's used for very different purposes. I mean, in the immigration context, we're talking about whether somebody's going to be deported. We're not talking about whether they're going to be sent to prison.
Well, certainly there are certainly criminal consequences to immigration determinations and vice versa, but I think there's kind of a bigger point here. The government's seeking to rely very heavily on a contextual distinction between contemporaneous offenses and prior convictions. But the point is that is not a distinction that has ever mattered to Congress. It's not a distinction that has ever mattered to circuit courts.
Here's what I really mean to ask. How do we know that? How do we know it's never mattered to Congress or mattered to us for that matter, because we've never decided a case based on that point? I'm saying I think it matters. I think your point seems to be, well, this court's never said it matters. We've never been asked whether it matters. That's my point.
Well, and to follow on that, wouldn't normal canons of statutory construction, we would look at the text, we would look at the structure of the statute, we would look at the broader context, we would look at the purpose and policy considerations, and aren't those all tremendously different in these two different contexts when we're talking about prior offenses and we're talking about the instant offense, right? It seems to me that the policy distinctions there are huge, the textual context is huge. It seems to me those would be exactly the sorts of distinctions we would make if we were doing ordinary interpretation of the language, and so identical passages of language in those two different contexts might have very different meanings.
And Your Honor, certainly context is a relevant consideration whenever trying to construe the meaning of a statute. But I think the text and the structure, as well as the context, all point this court toward a categorical approach in this case. Particularly,
What about a practical approach, counsel? I mean, according to the reading of 924C, we are asking juries to already make determinations with regard to the felony conduct. They're making those factual inquiries. Wouldn't it make sense then to go ahead and say, yes, you can make that inquiry and take it via a conduct-based approach?
and I would agree with you, Your Honor, if the crime of violence determination were a fact question. But what this court has stated, looking at this same language in James versus United States and in Leocal versus Ashcroft, both looking only to the text, the conclusion has been that this is a question of law put to a court, not a question of fact that a jury is capable of deciding. In the two kind of textual observations that have led this court, as well as every circuit court to decide the issue prior to DiMaia in 2018, is we see the subject of the residual clause, offense that is a felony, that's being modified by the phrase by its nature. This court, as well as the circuit courts, have looked at those two characteristics in conjunction and reached the conclusion that this is a question of law requiring courts in the abstract to consider the imagined ordinary case of the predicate offense. And I think that's consistent with some of the policy determinations made by Congress back in 1984 and 1986. When we look to Taylor versus United States, which this court decided in 1990, Taylor looked back extensively to some of the forms of debate and some of the legislative history behind the Armed Career Criminal Act. Now, the reason that's relevant is that this definition of crime of violence, as well as Section 16, were both enacted at the same time as the Armed Career Criminal Act by the same Congress, actually in the same act, the Comprehensive Crime Control Act of 1984. And at that time, what Congress was concerned with was categories of traditionally and typically violent crimes in ways to capture those through this legislation. And so
let me return you to something you said earlier, that this is a question of law. Am I not mistaken that at trial you argued, at least in the alternative, that this should be a jury question, that the substantial risk question ought to be put to a jury?
You are mistaken, Your Honor.
Okay.
At trial, both the government and defense asked the court to apply the categorical approach in this case. Now, it's true on the initial appeal, one of the co-defendants, Mr. Glover, appealed on the point that this should have been put to a jury.
Right.
Of course, the government advocated very strongly against that position at the time, arguing that the only reading was a categorical reading.
So
The
in a
government
way,
was
we
correct.
have both sides here kind of doing reversals on previous arguments they've made, whether that be in this case or previous cases.
I disagree, Your Honor, in kind of for this reason. We had argued under the categorical approach from the very moment we sought to dismiss the indictment pre-trial. We advocated for the categorical approach at trial. We lost again. We advocated for it on appeal. And then alternatively, as a Hail Mary, one of the defendants also advocated for a conduct-based approach. But I think the point here is that the government has taken a position in this case. And it's a position that it's been taking for 30 years. And the government at this late stage, 11th hour in the proceeding, is seeking to change its position and take the benefit not only of the conviction.
Why isn't that necessarily fair, though, in light of what we did in DiMaia? if I understand Mr. Ehrlich's argument correctly, it's not so much a opportunistic change in position as it is that once we identified in DeMaio what the statute means, at that point, don't we owe it to Congress under constitutional avoidance principles to try and interpret the statute in such a way that's not going to lead to it being unconstitutional?
Your Honor, the government had all the information it needed if it were to change its position on a principled basis from Johnson versus United States in 2015. It chose not to do so. It also had all the information it needed as to how this court would be construing this very language from Leocal versus Ashcroft in 2004. The government's change in position post-Amaya was simply a recognition that the government is on the losing side of this argument. And that is not a principled reason, especially given that the doctrine of stare decisis finds its greatest strength in questions of statutory interpretation. And I think that's an important part of this case.
But counsel, as the 11th Circuit has stated, the constitutional avoidance canon is an elementary rule. And Hooper versus California tells us that we have to find every reasonable construction of a statute in order to save it from constitutional avoidance, right? So here, it doesn't require the best reading. It just requires a plausible reading. Mr. Ehrlich's argument is correct that the word offense can sometimes mean conduct. And so even if there is a 10% chance that that the language here allows for a conduct-based approach, aren't we required to apply the avoidance canon in order to save the statute?
And let me jump in and add to that. In fact, we've already done that before, have we not? Take Skilling against United States, for example, when we had the honest services fraud case. What we specifically did in the face of potential ambiguity in that statute was to say the only way that the government can win on a claim for honest services fraud are based on bribes and kickbacks, and we restricted everything else so that we avoided the same vagueness problem. What prevents us from doing it in this case?
In Your Honor, to kind of combine these two questions, certainly there are three instances in the modern court where this court has reached for an arguably inferior textual reading in the name of constitutional avoidance. The Skilling case, in addition, Bond versus United States, and NFIB versus Sebelius. But the point is that the separation of powers gives us the outer limits of the application of constitutional avoidance, and it does throw it through based on a plausibility standard. That's a standard articulated by Justice Scalia in 2005 in Clark versus Martinez. And the problem with the government's conduct-based approach and its vehicle of using constitutional avoidance is that its reading is not plausible, and it's not plausible for four reasons. First, it's irreconcilable with the plain text of the statute. Second, it conflicts with how this court has already interpreted the same in similar language. Third, it offends the separation of powers. And fourth, it cuts against the rule of lenity in the breadth of congressional intent. So there are two textual problems with the government's proposed conduct-based approach. The first was mentioned in the government's petitioner argument, which is what meaning or effect could it possibly give to the phrase by its nature? This is an observation made by many circuit courts over the last 30 years that a conduct-based reading doesn't give any meaning to by its nature, but a categorical approach by its nature is central to the interpretation.
So anytime we see the language by its nature, it requires a categorical approach?
Anytime we see the language by its nature combined with the subject offense without any other reference to specific fact-based conduct, that results in a categorical approach.
So
Why is the government's interpretation of by its nature as requiring a specific look into the facts of the individual case plausible? Couldn't you look at the nature of the crime being committed in that particular case?
So to answer that question, Your Honor, we have to look not only to the language, but also to the structure of the provision itself. So we all agree that the subject of by its nature is offense. So we're thinking about the nature of the offense. Now the government seeks to bring that into a conduct-based approach through some language from this court in Najawan versus Holder, where this court stated in a vacuum the word offense could refer to elements as defined by Congress, or conduct that is punishable as an offense. It could have a flexible meaning. But the structure of this particular provision forecloses that meaning in this case. And here's what I mean. If we look to the structure of the 924C definition of crime of violence, it exists in parallel. There are two subsections, subsection A called the elements clause, subsection B the residual clause. Neither of them actually have the subject in those clauses. Instead, the subject is above and both clauses refer to offense as a felony. Now, Leocal versus Ashcroft construed the elements clause to require a categorical approach. The government is not contesting the categorical approach as applied to the elements clause. So if the government is correct today, subsection A would have a categorical approach, subsection B would have a conduct-based approach, yet they both refer to the same subject. So offense that is a felony would simultaneously mean the elements as defined by Congress.
Are you taking the government's argument as a concession on that, as a concession that paragraph A doesn't require or requires a categorical approach?
I think, no, the government believes that is the correct reading in light of this court's opinion in Leocal versus Ashcroft.
We didn't get a chance to question Mr. Ehrlich about that, is my point. Is there at some point in their briefing they've conceded that point?
Yes, Your Honor. On page 21 of their brief, they concede a categorical approach to subsection A.
And so your point is it's just outrageous to say that there'd be a categorical approach to an elements clause and a conduct-based approach to a residual clause.
I wouldn't use that term.
It's just not in the natural order of things, I guess, huh?
I would point this court to Clark versus Martinez in 2005, where this court held that a single word in a statutory provision cannot be a chameleon, meaning one thing for the purposes of one subsection and another thing for purposes of another subsection. The government's interpretation does just that, disrupting the internal coherence of Section 924C. But there are bigger problems when we ask questions about precedent, which is the second reason that a conduct-based approach is...
Counsel, in your brief, you referenced U.S. v. Santos first for that proposition. And in Santos, in fact, the court said you can't apply different meanings to different factual situations as they arrive, not to different provisions in a subsection. Is Martinez different? Because in Santos, which is the first case you referenced for that proposition in your brief, the question is, what is the meaning of proceeds? And that one of the justices, Justice Stevens, was arguing that, well, proceeds in some contexts, most contexts, factually in the world would be receipts, but it could also mean profits in some contexts. That, most of the court said you can't do. They did not say, in fact, they said just the opposite, that the same word couldn't mean different things in different subsections of a statute, which is what we have here. We have two different subsections, both which incorporate the word offense or phrase, offense that is a felony. I don't think Santos supports your proposition at all. Does Martinez more properly support your proposition?
Yes, Your Honor. So Martinez dealt with this same structure here, where you had the same subject, multiple subsections, and then in Clark versus Martinez, you also had the same remedy at the end, and the court held under both Santos and Clark versus Martinez both get at the same fundamental canon of interpretation, which is the consistent usage canon. In terms of the internal coherence here, I think Clark versus Martinez is the most instructive point. Now, the government seeks to essentially set aside Taylor, or at least disputes what this court was doing in Taylor versus United States when it first applied the categorical approach to the Armed Career Criminal Act. But I think it's important to note that the best evidence of what this court was doing in Taylor is the Taylor opinion itself. And when we take a close reading of that opinion, this court started right where we're saying it should start here, which is the text of the statute. This court then went to the legislative history, and only after doing both of those, this court looked to practical or workability concerns.
On that point, let me ask you this question. Is it your position, you're taking a vagueness argument, unconstitutionally vague. Is it your position that this statute is unconstitutionally vague in every instance? In other words, that every single defendant looking at this statute would not understand what it prohibits or what it enhances?
With respect to the residual clause, yes, Your Honor. Of course, we're not challenging the elements clause, which is also part of the definition of crime of violence.
I mean, as I look at the statute, you're saying, for example, your clients here who robbed a convenience store with a sawed-off shotgun, your clients didn't know that their conduct was substantially likely to involve the threat of violence? They didn't know that?
Your Honor, the way you just described it, they would have known that. And if we were taking a conduct-based approach, perhaps the outcome would be different.
But I think you're begging the question. That's my problem, is sure, if we decide at the outset, conduct-based versus categorical, but I'm looking at it from a broader standpoint and trying to understand which of those approaches to apply in the first place. And what we've always said about a void for vagueness construction is that it has to be vague in all instances. It can't be vague sometimes and understandable other times. And so that gets to my point that, sure, some people may not understand whether their conduct, for example, mere possession of a sawed-off shotgun, does that involve a substantial risk of violence? Maybe, maybe not. That might be vague. But when somebody takes a sawed-off shotgun into a convenience store and points it at the clerk, everybody knows that involves a substantial risk of violence. I don't see how that can be vague, particularly as to your client. And if it's not vague as to your client or not vague in all instances, I don't see how it meets our jurisprudence on void for vagueness.
The store clerk certainly thought it was a risk of violence.
And I agree, Your Honor. And I'd like to address, Justice Sherwin, your question in two different ways. First, looking to the language of the statute, if all it said was conduct that creates a substantial risk of injury, I would agree with you not only in your conclusion, but also with the government in a conduct-based approach. In fact, we see other statutes that are worded just that way. But where I disagree with you is what this statute, what the inquiry requires. And what it requires is that we consider the nature of the offense as defined by Congress. So while Mr. Davis and Mr. Glover would certainly know that their conduct or the acts in that case presented a risk, what an ordinary citizen, including them, would not know is whether the nature of conspiracy to commit Hobbs Act robbery presents that risk. And this court has held in James versus United States.
Why wouldn't they know that? I mean, isn't it, I remember learning in first-year criminal law that robbery is one of the so-called dangerous felonies, that the mere act of it is likely to lead to injury.
Well, certainly if we were talking about the substantive offense, I would agree with you. Hobbs Act robbery is a dangerous crime. But we're taking a step back from that and talking about a different count, conspiracy to commit Hobbs Act robbery. And then now we're taking an even bigger step back from that and asking the question for purposes of 924C, whether the nature of conspiracy to commit Hobbs Act robbery presents this risk.
I don't see that as a difficult sort of trail of crumbs to connect.
Well,
if you're willing to concede that Hobbs Act robbery is a dangerous crime, why isn't conspiracy to commit it dangerous? And I don't see the disconnect there between those three offenses.
Well, and Your Honor, in every circuit right now that's decided the question would disagree with you, including the Fifth Circuit, which held in this case that conspiracy to commit Hobbs Act robbery is not a crime of violence under the categorical approach. And so I think that
just so I'm clear, your clients were convicted of conspiracy to commit Hobbs Act robbery as well as Hobbs Act robbery.
as well as the 924C
Right.
counts using
So
those
it's
as
not just a
predicates.
conspiracy claim, is my point.
That's correct, Your Honor. And we're not challenging the 924C as to the substantive offense. only as to the conspiracy
Okay.
because of the inchoate nature of conspiracy.
All right.
Now,
Tell us about the rule of lenity and its application here.
And I think the rule of lenity is a very important counterbalance to the government's use of constitutional avoidance. Of course, the rule of lenity is a historical rule before this court, advising courts to construe criminal statutes narrowly. And the reason that courts are meant to do so is to enforce the separation of powers by avoiding the creation of a new crime that Congress may not have intended. Now, under a categorical approach, we have a set of traditionally or typically violent crimes that 924C has been able to reach. But if we were to switch approaches and adopt a conduct-based approach, 924C could potentially reach any federal felony, even ones that no one ever thought of as typically violent before.
So the question is this: why don't we decide this under lenity grounds? Why are we deciding it under vagueness, constitutional vagueness grounds, as opposed to just applying the rule of lenity?
Well, certainly if the government were to get its way, the rule of lenity would have no effect on this case because the government believes we're not even entitled to a new trial on its harmlessness argument, even if this court were to take a new approach. But the biggest problem with lenity is the breadth of application of 924C, and it offends not only the rule of lenity, but also what we know about congressional intent. When Congress first enacted 924C, it was part of the Gun Control Act of 1968. At that time, 924C applied to any felony. It wasn't until 1984 that Congress decided to narrow the application of 924C to just crimes of violence. If we were to adopt a conduct-based approach, it wouldn't go as far as any felony, but it could be potentially applied to any felony. So example we use in our briefing is an alien entering the United States while possessing a firearm to protect himself and his family from cartel violence. Illegal reentry or illegal entry or reentry after deportation has never by any court been considered a typically violent crime.
I understand your concern on that, and that is also a concern of mine, that you've got a potential issue of there are some cases, outlier cases, in which the statute could be construed so broadly that you could find yourself under 924C even though you didn't mean to. But to me, those issues can be resolved in two ways. If we're making it a jury issue, which is, I believe, something you said that you would be agreeable to as well, why not permit our district judges to provide an instruction that the gun actually has to be used in the commission of a crime before a jury can find somebody guilty under those elements? And as well as let district judges use their powers under Rule 29 if they choose to have a judgment of acquittal. Why doesn't that solve the problem under either constitutional avoidance or under the rule of lenity principles?
And Your Honor, that may have been a solution to the problem before 1995 when this court decided Bailey versus United States, holding that the use of a firearm must be active use and didn't cover mere possession. In response to that decision, Congress amended 924C in 1998 to include not only use but also possession as giving culpability under this statute. So one of the problems in terms of the breadth of application is that by the mere possession, it's certainly foreseeable that a prosecutor could convince a jury that a person was culpable under 924C in such a way that they would never have been viewed as before. But I think in another important point, and it's one of the biggest takeaways from this case, goes to the separation of powers. As this court stated just last year in Jennings versus Rodriguez, quote, spotting a constitutional issue does not give a court the authority to rewrite the text of a statute. And if we were to adopt a conduct-based approach in this case, that's exactly what we would have to have happen. Congress wouldn't have to make very many changes to the statute, but in light of the text now as it's been interpreted by this court in 30 years of interpretation before the circuit courts, it would have to be rewritten, and this court does not have the authority to do so. And it's for these reasons we ask this court to affirm the judgment of the Court of Appeals for the Fifth Circuit and hold the 924C residual clause void for vagueness. Thank you.
Thank you, Counselor. I think a round of applause is in order.
Before everyone takes off, I believe Professor Beck wanted to say a couple words, so we'll let him do that.
Can I just say for a moment, just as the Chief Justice of this moot court and as Dean of the Law School, we have two incredible Texas Tech folks right here, law student and graduate. Robert, you did a fantastic job. Let's give Robert a round of applause.